Well, good afternoon if you're on the East Coast, and good morning and aloha if you're way out west. And welcome to this, I don't know, special holiday edition of the Thompson Coburn Higher Education webinar series. Also, if you have watched these before, you may have noted that this is, I think, the first time, at least for our higher education practice, that we have attempted live video, along with the webinar. So if you like it, give us feedback. I'm going to prompt you in a minute, or I should say beg you is more likely, to fill out that post-webinar survey, and that would be a good time to let us know if you think the video makes a difference, or as they used to say, you think we have a face for radio and should stick with the voiceover. So please let us know, and we'll try to take that feedback. Moving right along, let's get into some housekeeping at the top of the hour while folks are still joining. First of all, getting into the mini widgets that are present in and around the presentation. First of all, you've got the Q&A widget on your screen, and we would ask you throughout the presentation, if you have questions, you can drop them into that Q&A box. And then at the end of the presentation, if we've got time left, which we hope to have a little bit of time left, then I'll go through and try to moderate questions, and we'll let our panelists see if they can give you some good answers. We also have a resource widget, which has, in this case, slides for the webinar. And we always encourage you, whenever we do one, to check out the resource widget just to see what all is there, because we welcome you to download it if there is something waiting for you. The help widget has some answers to commonly asked questions. So among the many widgets, the help widget can be useful, particularly if you're having technical issues during the webinar. Wanted to speak just a minute about continuing legal education credit. So many of you on the line we know are lawyers. I'm going to look at my script here for this portion. So today's presentation is accredited in California, Illinois, and Texas for 1.5 hours of general credit, in Missouri for 1.8 hours of general credit, and in New York for 1.5 hours of professional practice credit for experienced and transitional attorneys. New York clearly felt strongly about having the longest title of the bunch. We award CLE based on attendance for the entire presentation, which today will be 90 minutes. As required during the presentation, we're going to display certain secret words 3 times. I believe there will be 3 multiple choice polls during each time you see a secret word. And please just take a moment to select the item there on the page that corresponds with the secret word and select it so that you can get credit for your CLE. And we certainly want you to. And then finally, I mentioned earlier, and it really is true, we read the post-webinar surveys. They provide a lot of great feedback. And so we're always grateful for those of you who can stick around for just a few minutes and fill that out and give us any thoughts, feedback, ideas that you may have. If you don't know us, by the way, Thompson Coburn is a law firm traditionally headquartered in St. Louis, Missouri. We have offices around the country. And in fact, our presenters today are from all over. A couple of us are sitting in St. Louis. One is out in Washington, D.C. One is down in our Dallas office. Within our law firm, which is, again, nationwide, we have 400 plus attorneys. We have a group of attorneys who spend all of their time serving institutions of higher education and who comprise our higher education practice. And we do a lot of different things for institutions. And it won't surprise you to know that one of the things we assist with on a pretty frequent basis is compliance, understanding various non-discrimination laws like Title VI, which we're going to talk about today. Speaking of which, let me introduce you to the 3 people who are really going to be pulling the heavy oars. I'm in the enviable role of moderator. So the folks you're really going to hear from are Scott, Stephanie, and Leah. I'll start with Scott Goldschmidt, a partner in our higher education practice. Notably, Scott spent almost, I guess, about 9 years, right, Scott, at Catholic University in Washington, D.C. as Deputy General Counsel, finished up as the Deputy General Counsel there. And I note that because those of you who are in-house know that when you are in-house counsel, you spend a lot of time dealing with human resources and non-discrimination law type issues. So it's no surprise that Scott is among the attorneys in our higher education practice who's very deep in non-discrimination law and will be one of the folks leading the charge today. Like Scott, Leah Northerner also has spent time in-house and also has a focus on non-discrimination law. All of us do a lot of different things for institutions, but your 3 presenters today, like I said, are particularly deep in the Title IXs and Title VIs and Title VIIs and all the titles of the world that are impactful, particularly when you're in-house trying to deal with these types of issues. And then finally, rounding out the group, Stephanie Fredman also spent time in-house like Leah and Scott. So again, really bring that perspective and also has an emphasis in labor and employment and non-discrimination law amongst the many things she does for institutions of higher education. So just delighted that you could be with us today, and so grateful, Scott and Leah and Stephanie, to you all for making time, because I think this Title VI topic is going to be an increasingly important and high-profile one in the months and years to come. So I'm really just genuinely grateful to you all for putting together this content for our community. So with that, Scott, oh, I should forget, I'm supposed to introduce myself. I'm Aaron Lacey. I'm the moderator today and the co-chair of the higher education practice. And here's our syllabus. And I'm actually going to kick it to Scott to walk you through the syllabus and then get you started.
Thank you, Aaron. Yeah, you can't forget yourself. Appreciate the introduction. Happy you all are here, certainly with us. Just to echo what Aaron said, I think this is a really important topic for institutions to kind of to either keep on their radar or put on their radar. As you know, or may know, we've spent a lot of time in recent webinars on Title IX, other non-discrimination topics. For good reason, the government is focused on it. We've had many regulations and regulatory packages addressing that, and in particular. But as in recent months, we've seen a renewed emphasis on Title VI, and as we'll hopefully explain later in the presentation, we think this is going to be a really big, important topic for the new incoming administration, and one that schools really should get ahead of and start thinking about if you haven't already. So I'm going to start us off with an overview of Title VI, just to kind of get bearings. We're going to go over OCR's guidance, right, on Title VI. There's been a number of decisions and resolution agreements, which we're going to try and mine for important pieces that the government is trying to tell schools about how they expect compliance to go. We're going to get into what we think the Trump administration, again, assuming there is a Department of Education, we think there will be, but what are they going to focus on? How are they going to enforce Title VI? And we're going to round it out with some best practices and tips for compliance. So getting into the Title VI overview, this is just a high level piece of it. So for those of you that have seen our Title IX presentation, it's similar, right? Not many words packing a lot of punch here. So in the Title VI statute, basically says no person in the United States, and again, we're going to go over this in detail, shall, on the grounds of race, color, or national origin, be excluded from participation in, denied the benefits of, or subject to discrimination under any program or activity receiving federal financial assistance. Again, we're gonna go over this in detail, but this is the underlying statute that's kind of girding the presentation and the compliance obligations. So important to note, right, when we're talking about Title VI, we're talking about Title VI of the Civil Rights Act of 1964. Many may be familiar with Title VII as well, which deals a lot with employment. Title VI is enforced by the U.S. Department of Education by their Office for Civil Rights, OCR. Again, kind of similar to, it's one of the other areas that they do, aside from Title IX and kind of other non-discrimination laws that they enforce. Also important to note, the Department of Justice has an involvement in Title VI as well, as with Title IX. They coordinate federal agency implementation and enforcement of Title VI and act as the legal representative of the United States if litigation is ever required. So we talked about the statute says race, color, or national origin as our protected categories. But a really important piece of Title VI is kind of how it's been interpreted by OCR, the Office for Civil Rights of the Department of Education. So Title VI's protections from race, color, and national origin discrimination extend to students who experience discrimination based on actual or perceived shared ancestry or ethnic characteristics. Here is in news recently, students of Jewish, Palestinian, Muslim, Arab, or South Asian descent, or actual or perceived citizenship or residency in a country with a dominant religion or distinct religious identity. And these pieces in particular are what's driving most of the recent activity with the Office of Civil Rights and resolution agreements. Now, it's important to make a distinction. Again, this is a pretty nuanced point, but Title VI does not prohibit discrimination based on religion, right? So whereas other statutes may, Title VI does not prohibit discrimination based on religion. But OCR, and interpreting courts have made clear that institutions have a responsibility to address discrimination against Jewish, Muslim, Sikh, Hindu, Christian, and Buddhist students, or those of another religious group, when the discrimination involves racial, ethnic, or ancestral slurs or stereotypes, a student's skin color, physical features, or style of dress that reflects ethnic or religious traditions, or where a student came from is perceived to have come from, right? Including things like a foreign accent, foreign name, or association with a foreign language. So the guidance and regulatory agencies make clear that we're not prohibiting discrimination based on religion, but these other characteristics that could be associated with certain ancestries and religions. That is part of Title VI's mandate, and that's what the government is trying to prevent discrimination based on. So if you're here as part of an institution of higher education and you receive federal financial assistance, and that means Title IV, federal financial aid, grants, et cetera, which we assume is most of the audience here, Title VI applies to all the operations of your institution, right? That includes everything in the boxes here, from admissions to recruiting, your education program or activities, class assignments, discipline, athletics, et cetera. Title VI's coverage in the employment section is a little more limited. As I said, Title VII in the same act is the primary vehicle to address employment discrimination, but it does have a limited context. For the most part here, what we're going to be talking about is discrimination based on race, color, national origin in the student context, in the context of those things in the boxes on the right of the screen. Title VI's regulations are outlined at 34 CFR Part 100. Title VI regulations have not been updated since 2000, right? So it's been 24 years or so. We've had the same regulations. Again, they are not nearly as detailed, specific, prescriptive as Title IX's regulations. So what we see is a lot of interpretive guidance, right? So, and the Department of Education, which we'll talk about, OCR, Department of Justice, they've tried to fill in the gaps. They've tried to say what this actually means and kind of how schools should have guidance to implement it, but we're not dealing with regulations here as we did with Title IX recently. And based on the current agenda, there's no plan to implement Title VI regulations anytime in the near future. And with that, I'm going to kick it over to Leah to really get into the types of Title VI claims that we'll talk about.
Thank you so much, Scott. I want to start by saying, for those of you that have joined us in our recent Title IX presentations or taken our Title IX trainings, a lot of this is going to sound very familiar. So we're going to kind of go through it fairly quickly, assuming that you guys are familiar with some of these definitions, but we do think it's important to go over them in the Title VI context. So when we're talking about Title VI and Title VI discrimination, there's various types of discrimination that we can see here. So the first one we're going to talk about is disparate treatment. And disparate treatment is the intentional or knowing discrimination that one typically thinks of whenever we're talking about discrimination. So this is the recipient of the federal funds, so the school is treating persons differently or otherwise knowingly causing them harm because of those protected characteristics that Scott discussed. This is often proven via direct evidence, or it's less often proven via direct evidence. That would be someone coming right out and saying, yes, I discriminated against them on these basis. It's often proven through circumstantial evidence of what was occurring, maybe some stray comments that were made, those sorts of things. When we're looking at disparate treatment, OCR looks at a 3-step test to determine if a school engaged in that disparate treatment. Again, if you're familiar in the Title IX context or even in the litigation context, this is called a burden shifting framework that we have here. So the first thing that they're going to look at is if we have a prima facie case of discrimination. And what that means is, do we have those basic elements just on its face when we're looking at the claim here? Are those basic elements there? So they're going to look at if the student is a member of a protected class. So if they are not a member of one of these protected classes, the claim goes away right there. They are going to look at if the student was eligible to participate in that education program or activity that is allegedly impacted or denied or adversely impacted for the student. Was that student treated in an adverse manner if they were eligible for that education program? So this means that if their grades weren't good enough maybe to get admission to the school, they wouldn't have been eligible to get in anyway. So if their claim is that they were treated adversely on the basis of their race by being denied admission, if we have proof that they wouldn't have been eligible anyway, regardless of race, because of whatever criteria you use, that would kind of knock it out at that point. And then the last part of the prima facie case is whether there was another similarly situated student outside of that student's protected class, so someone from a different race, national origin, et cetera, who was treated more favorably. So they need to show that there was someone else that was treated better than them outside of their protected class. If all of that is there and we've established that there's a prima facie case, our next step is to ask the school to provide a legitimate non-discriminatory basis for its actions. So this is the time for the school to provide its explanation for why it took the action that it did. This is often a kind of a checkbox step. It's pretty easy for someone to come up with a reason for the actions that they took. And so then that leads us to step 3, which is determining whether the school's explanation is just pretextual. And that means, is it not the true reason? Is it kind of just a cover for that discriminatory action? And this is where we're really going to be looking at those circumstantial elements to determine if it was pretextual by looking at the circumstances and what was going on around the situation when it happened. Now, the counter to disparate treatment discrimination, and this is a very important point that we'll go into later when we're talking about the kind of our predictions for the new incoming administration, is this difference between disparate treatment, which we discussed, which was the intentional discrimination, versus disparate impact, which is more, it's unintentional. It's typically a neutral policy. It typically involves a policy, but it's a face neutral policy or practice that disproportionately impacts in an adverse manner individuals of a certain race, color, or national origin as compared to individuals outside of that protected class. So here we're really looking at the impacts. It's not necessarily that the policy itself was developed with a discriminatory intent. It's really the impact of it. Does it impact disproportionately in an adverse manner certain specific individuals in that protected class? Another type of claim that we see in this area is hostile environment harassment. Again, if you are familiar with our Title IX context, you'll be very familiar with hostile environment. It's very similar. So you have unwelcome conduct that is subjectively and objectively offensive. So that means subjectively, it is offensive to me, myself. I'm the one experiencing it. I find that conduct offensive. Objectively is to the general public. They would find it offensive as well. It is severe or pervasive, so really bad conduct or happening a lot. And then it limits or denies that student's participation or benefit in the education program or activity. Now, these elements, we're going to kind of break them down. So conduct is unwelcome if the person did not request it or invite it and regarded it as undesirable or offensive. And we like to point out here again, similar to the Title IX context, that simply acquiescing to this conduct or failing to complain or resist does not mean that you find that person found that conduct welcome. It really is their kind of internal appreciation or understanding of the conduct that determines whether it was unwelcome or not. And conduct does not have to be directed at a particular person for that person to find it unwelcome. So they can just be in the same vicinity as someone else experiencing that conduct. This happens a lot in the online context where we see, maybe two people engaging in, harassment towards one another. And maybe I'm a third person that's not involved at all, but I'm experiencing it by seeing this conduct occurring online. That can account for hostile environment here. Again, we talked about the definitions of subjective and objective offensiveness, and then severe and pervasive. We just have some definitions there for you. And we like to point out that when it comes to a hostile environment, we're looking at that totality of the circumstances. There really isn't one thing typically that is going to help or to make you check off that there is a hostile environment or not here. We're looking at everything that is occurring. And that's why investigations are so important in these contexts, because you really want to be able to look at everything that happened around this unwelcome conduct. So we're looking at the context, nature, scope, frequency, duration, location. Those can all have an impact on how a person perceives a particular behavior or action. It can have an impact on the pervasiveness, the severity, etc. Again, same things, identity, number, age, relationship of the persons involved can definitely have an impact on those as well. Generally, we mentioned that it has to be severe or pervasive. So generally, the less pervasive the conduct, the more severe it must be to establish a hostile environment. So if we have conduct that only occurred once, it typically needs to be pretty severe for it to count as a hostile environment under Title VI. And the converse is typically true as well. The more pervasive something is, typically the less severe it needs to be. So in most cases, a single isolated incident is not sufficient to establish a Title VI violation. However, in some cases, the school may need to respond to that action. And typically we recommend at least looking into that action in all cases to make these determinations based on, again, that totality of the circumstances. So OCR, if they find a hostile environment violation, OCR must find that it was based on race, that there was a hostile environment based on those elements that we discussed, based on race, color, or national origin. And then they need to see that the recipient had actual or constructive notice of this hostile environment. So this means that in order for a school to be found liable for OCR to find a violation here, the school has to have actual or constructive notice. OCR wants to make sure that you're given a chance to respond and address this conduct. So that's why this element here is really important for schools. And then again, as part of that, having that actual or constructive notice, OCR will look to see if the school took prompt and effective action to end that harassment, eliminate any hostile environment and its effects, and prevent that harassment from recurring. So they really want to see that action taken here. And I know a lot of schools get concerned, well, what if we can't end it right away, or if it continues going? They really want to see that you're taking different actions, you're making changes based on the events that have occurred and the circumstances that pop up, and that you are doing your best to prevent that from recurring on your campus. One of our last types of claims we see here is retaliation. The Title VI regulations prohibit retaliation for any individual who exercises their rights under Title VI. So this means no intimidation, threats, coercive behavior, discrimination against any person for the purpose of interfering with them exercising their rights under Title VI. Now, penalties for noncompliance. So if OCR were to find a violation for that a school violated Title VI, the Department of Ed may undertake proceedings to suspend, terminate, or refuse to continue federal financial assistance. This is relatively rare, but we do want to put it out there that it does happen. It is a possibility. The Department of Justice may also enforce Title VI in court. So that is another option. And then there's also the option of private litigation of the individual who experienced that discriminatory conduct, filing a claim against the institution for intentional discrimination. There's no private right of action for disparate impact claims. Those can only be initiated by OCR, but there are intentional discrimination claims that can be brought in court. And Stephanie will take us through some of the litigation here in just a minute. But first, we have our first secret word of the day. So for those of you that are trying to get CLE credit, our first secret word is quarterback. So if you would select the secret word from the choices below, again, the secret word is quarterback.
Hey, Leah, while we're waiting for folks to hit the correct button here, you mentioned on the last slide this concept of private right of action, and I know we have a number of attorneys on the line, but I also don't want to assume that everyone is an attorney, and I was wondering if you could take just a minute to tell us what you mean by private right of action.
Right, so that means that this would be an individual bringing a claim, suing the school, essentially. So that is a private right of action that they have the ability, or that they would not, in this case, have the ability to sue the school, or would, depending on what the claim is, disparate impact versus intentional knowing claims.
So So fair to say the upshot in non-lawyer language is an individual can't sue the school for the school's failure to carry out their under obligations under Title VI.
Correct. In addition to the OCR investigations and all of those other things, there are many different avenues. But yes, a private lawsuit by an individual is definitely one that is on the table.
Which is a big difference, particularly for the plaintiffs' attorneys of the world.
Yes, absolutely.
Yeah, no doubt, no doubt. All right, pretty close. Are we close? Folks have managed to click quarterback if it matters. Yeah, hopefully. All right, moving right along, I guess.
Sorry, moved through that a little too quickly. So I'm really excited to talk to you about some of the recent Title VI litigation. There's some really interesting things that are happening in terms of litigation right now. And we're going to go through a couple cases. Some of them do touch on only Title VI. Some are going to talk about some other both constitutional challenges as well as Title VII, which for those of you who might not be familiar with it is the anti-discrimination law in the employment context. So we're going to talk just about litigation really in sort of this anti-discrimination context. And a lot of it does go through some of this recent Title VI litigation too. So probably the biggest case in the last couple of years that has touched on these topics is the Student for Fair Admissions versus the Harvard and UNC case. This is a case that you all are likely to be very familiar with. It's the case that the Supreme Court held that race-based affirmative action programs were unconstitutional, and that they also violated Title VI. This holding is interesting because the majority opinion really doesn't discuss Title VI in great detail, but it instead goes through a whole constitutional analysis. And we could do an entire presentation just on that decision. We've done an entire presentation just on this decision in this case. So you probably can find it on Thompson Coburn's website if you're interested in looking back through that. But I want to talk about what the Title VI component of this case is. So in a concurring opinion, there is a lot of discussion about how these programs that use race as a factor in admissions and in these affirmative action programs violate Title VI. So one quote from that concurrence is that Title VI applies to recipients of federal funds covering not just many state actors, but many private actors too. In this way, Title VI reaches entities and organizations that the Equal Protection Clause does not. So the majority opinion had gone through, this whole analysis under the Constitution. And here we also get this idea that Title VI is going to be broader. It's going to apply to more people. It's not just going to be those public institutions that the Equal Protection Clause is covering, but it's also going to be private institutions as well. So really, the case and the justices there are saying that under both the Constitution and under Title VI, you can't use these types of race-based programs as a factor in admissions and in the admissions process. The case is interesting because following the decision coming down, there was a number of challenges that arose, challenging other DEI programs, affirmative action programs, just admissions policies generally. And some of them were under Title VI. And just the impact of the case and the holding and the language of it really has already we've seen sort of this ripple effect through litigation. So one really new decision is related to military schools. So just the other day, the District of Maryland held that the Naval Academy has established a compelling national security interest in a diverse officer corps in the Navy and Marine Corps. So they held that the Naval Academy actually can use race as a factor in admissions due to this compelling interest in this diverse population needed for the United States military. Another place where we've seen challenges in the Title VI context in litigation is in legacy admissions. Many of you may be familiar, it was in the news probably about a year ago or so, that there were challenges to Harvard's legacy admissions policy. Harvard's not the only school where these challenges arose. This was really at the OCR level, but investigations were opened under Title VI into the impact of these legacy programs. There was a push both from on the state and federal level to get rid of legacy admissions. Right now, not so much has happened on those larger scale initiatives, but we have seen a number of schools get rid of their legacy admissions policies and instead focus on other factors in admissions rather than legacy. The argument being that legacy is sort of promoting race discrimination in a way that it is supporting those who have come before in terms of who has already been at the school. And so that is how the Title VI component came into it, is that it was argued that these legacy programs are discrimination based on race. So as I mentioned, a number of schools have done away with their legacy policies in terms of admissions, but we've seen just some interesting things come out of that challenge as well. There's just general challenges with DEI policies. We're going to talk about a few on the next slide. And it's the idea that discrimination because of race is, that's where the issue is. So that's where these allegations come in and this litigation comes in. And we've seen some legislation, we've seen some state attorneys general make statements about scholarships and things, and we're going to go through a couple of them right now. Okay, so talking about financial aid and scholarships. So as I mentioned in the SFFA case versus Harvard and UNC, the Supreme Court said that race-conscious admissions processes violate Title VI. So the case itself did not discuss anything else that might be related to the admissions process. So that is, scholarships, financial aid, those types of things. However, we've seen multiple OCR complaints be filed that are challenging race-conscious scholarships. And many public institutions have stopped offering or promoting race-conscious scholarships. Following the decision coming down, we immediately saw that in certain states, such as Missouri, that the mandate there was to really get rid of those types of scholarship programs. And that was coming from the Attorney General, that all public institutions, really could not be offering these race-based, race-conscious scholarships. So there was policy from the Department of Education in 1994 that appeared to provide a roadmap for schools to develop a compliant race-conscious financial aid program. This was pulled back during the first Trump administration. It has not been replaced with anything at this time. And I'm previewing a little bit. Leah's going to discuss, as we said later on, about some predictions for the next Trump administration. So this is just one thing that happened during the first administration in terms of these scholarship programs. So some additional recent things that have been happening in the courts in terms of Title VI. So there were claims of a hostile work environment, discrimination under federal, state, and local law. And it was based on this sort of shared ancestry, race, ethnic characteristics, national origin piece that Scott was talking about earlier. This was at New York University. Here, the allegations were that Jewish students were being harassed and subjected to a hostile work environment and subjected to anti-Semitic comments and actions. This case is interesting because really of what's happened as a result of the case being filed. We know that the case did settle. There was a monetary settlement, but the one point I really do want to focus on with this case is that as a result of the settlement, that resulted in the creation of a new Title VI coordinator position. So this really parallels the Title IX coordinator role. It's going to look pretty similar to that. And it's going to be somebody that is going to be that go-to person on campus that can be somebody to get the complaints, respond, and act. So it's just an interesting thing. And I think we likely will start to see more schools kind of putting these roles into place. Another really, really new, interesting case is this Knight First Amendment Institute at Columbia FOIA litigation. So it's a case that was filed under the Freedom of Information Act. It is a case that's actually asking for the Department of Education to hand over their guidance of what they tell schools to do so that they are compliant with Title VI. They're looking to see if this guidance is at odds with First Amendment rights, which we'll talk just briefly about here too. So another sort of First Amendment piece, this is actually at the state level. So in Florida, through the Stop WOKE, Stop Woke Act, they sought to prohibit employers from requiring employees to attend any workplace training that really promotes employees to believe in a specified list of ideas that are related to race, color, sex, national origin. So this is a employer thing, so a little slightly different in terms of Title VI, and this is a state law thing. But what was interesting here is that the 11th Circuit actually upheld an injunction to prohibit the state from allowing this law to go into effect. And that was because they were saying that this is really just swapping out one set of ideals for another. And it was a violation of the First Amendment to do so. So really just focusing in on some First Amendment considerations. So as I said, there is sort of this seemingly overlap between the First Amendment and Title VI, and nothing in the Title VI regulations implementing it requires or authorizes a school to restrict any rights that are otherwise protected by the First Amendment. So an OCR enforces its laws within the jurisdiction, within its jurisdiction that's consistent with the First Amendment. So the fact that harassment might involve conduct that includes speech in a public setting, and if that speech is motivated by political or religious beliefs, a school still has to respond under Title VI. So it doesn't necessarily mean that they can just like lean back on the First Amendment and say that those students can say that because of that. So an OCR makes that clear that that's what has to happen. OCR has guidance on this, and they make a distinction between speech expressing views regarding a particular country's or policies or practices which is protected by the First Amendment, and then speech that is otherwise appears to be based on views about a country's policies or practices it's targeted at or infused with discriminatory comments. So just looking at that there and seeing that difference between one is has that discriminatory speech and conduct in it, and one is something that's protected by the First Amendment. All right, I am now handing it back to Scott to keep us going.
Thank you, Stephanie. And just to kind of to touch on the point you just made, that is a very distinct nuance that we're talking about here. So if you are presented with those kind of situations, certainly worth going to review some of this guidance and kind of really trying to figure out what is protected speech, what's not protected speech. And the line is definitely, can be gray and sometimes unclear there too. So as we talked about, the regulations kind of have not caught up with where we're at in terms of guidance and these kind of things. We did hear, and these are all live links, so hopefully this is just helpful for you to have it all in one place, but just kind of took a few of the recent decision or guidance documents, mostly from the OCR, from the Department of Education, also one from the Department of Justice, just to kind of have, as you're kind of going through it. If you're going to start with one, I'd recommend that May 2024 Dear Colleague letter. That is the more comprehensive document, or kind of one that lays out a lot of the current OCR's thinking on this, but all are just kind of important to have. And whenever DOJ or OCR puts out guidance, it is important to review it to see if anything's new, because a lot of times some of this is not written, and they could be taking different nuances, different interpretations to questions that we already have there. So we're going to talk about OCR investigations. So just wanted to level set about what that means. So hopefully this is a new topic for everyone. I suspect a lot on the call may have some familiarity with OCR, but for those that may not, OCR, and that should say Title VI there, but OCR has the authority to investigate potential Title VI violations in response to complaints, in response to someone petitioning OCR and saying, I think this violation happened, or independently. So if there's something in the news, OCR does have the right to kind of make that, begin that investigation. OCR's case processing manual is outlines the procedures, right? So OCR can start this, and it has to do it consistent with this case processing manual. And this, for institutions going through it, gives a helpful outline of what to expect, how to expect it, what OCR can do, and what they can't do. At the end of the process, there's a number of broadly speaking, resolution options. So the first, you could have a facilitated resolution or mediation. So if this is a student making a particular complaint, say of pregnancy discrimination or something like that, that could be a facilitated resolution with OCR. The second option is a voluntary resolution agreement, which we'll talk about in a sec. In this case, OCR does not make any findings, but the school and OCR agree to a resolution to solve the situation. Next is a resolution agreement. So OCR goes through the entire process, comes out with findings, finds that there was a violation, then the school can engage in a resolution agreement to satisfy their obligation. And last, if they cannot agree to a resolution, is an actual enforcement proceeding. That's when the bad consequences that I think Leah talked about in the beginning can happen, and certainly schools do not want to end up in enforcement proceedings there. So the voluntary resolution option, this is an option many institutions will invoke. Again, there's no findings, but the institution kind of during the investigation can request that OCR resolve the matter at any time before the conclusion, right? So as long as OCR determines the resolution agreement or settlement is appropriate, that can happen. It results in a resolution agreement publicly available. And again, that we'll go through in a sec. In 2024, there were 8 resolution agreements, 8 and counting, right, with institutions of higher education. The link there, these are all available online for you to read, right? We're going to go through a couple of them, but they are posted there. I think there's about 78 outstanding. So this is certainly something that will be on the mind of the forthcoming administration. Important to note as we go through them, they're helpful as guidance, but they're not precedent, right? Each situation is different. I'm going to go through these. There's going to be a lot of text in the slide there at a very kind of high level, just based on time, to kind of pull out 1 or 2 takeaways from each resolution agreement. We have the links there on each, but just in order to kind of see if past this prologue, or to kind of see what the government is concerned with, we thought it'd be important to kind of go through some of the different resolution agreements that the government has agreed to in 2024. And these are all kind of within the last 6 months. So the first agreement I want to talk about is the one with Lafayette College. Lafayette College is a private post-secondary institution. And again, certainly worth kind of going through, and the links are at the bottom, the full agreements and letters of resolution and press releases. But here, despite proactive efforts, right, besides the institution kind of making an effort to address a hostile environment, OCR had a couple of issues with the college's response. In particular, the college appeared to have a policy not to address allegations of harassment on private social media unless it constituted a direct threat. That is something that OCR said was inconsistent with Title VI and the law. Also, the college acted inconsistently with responses. We're going to talk in the final section. Stephanie's going to go through some best practices. These will all be listed there and kind of takeaways from OCR. But for here, I think the big takeaways, right, are policies that didn't address social media or had inconsistent application are the ones that drew OCR's higher. Next, agreement with the University of Michigan. Again, this is a large public institution. Here, OCR's concern was the university did not take action based on the fact that it was protected speech, right? And so, as Stephanie went through, while OCR and Title VI make clear that you can't discipline speakers for protected speech, there are obligations under Title VI to take steps necessary to ensure or prevent a hostile environment. So the fact that the university kind of stopped and said, this is protected speech, we're not going further, was what OCR had issue here. Next, agreement with Brown University in July. Here, OCR's concern was the university's inaction, right? So these are a lot of these have no findings, so I'm not kind of casting these definitively. This is just kind of what was in OCR's report, what they had concerned with. But OCR was concerned the university here had reports, acknowledged receipt, and really kind of did not much else, or they conditioned a fuller response on the complainant kind of replying to emails, right? OCR says, regardless of whether a complainant replies, regardless of this, once you're on that notice, as Leah talked about, once you have actual or constructive notice, you might have an obligation under Title VI to address the hostile environment. I see there's another Title IV typo here. I think we do a lot of Title IV, so that's the confusion there. So all of these should be Title VI, if not there. Next, in agreement with Drexel University. Again, Drexel is a private nonprofit institution. Here, I thought it'd be helpful to kind of go through some of the proactive steps that OCR listed in their agreement, right? So a lot of schools kind of OCR credits them for taking proactive steps. I think this could be helpful for institutions kind of saying, what do we do when we get a Title VI complaint? Here, OCR thought it was a positive step that Drexel issued multiple public statements condemning anti-Semitism, offered support and resources to students, convened meetings with the campus Jewish and Muslim leaders to reiterate resources and options, increased security patrols, had mandatory residence hall meetings to reinforce importance of respecting property and others and religious symbols. And then the rabbi from Hillel conducted training specific to anti-Semitism for investigative staff. Despite all these proactive steps, OCR did still have a few concerns, right? So mostly it was the misapplication of the Title VI standards when they had it. So the university here, Drexel, didn't consider that harassing conduct need not always be targeted at a particular person in order to create a hostile environment. And the university failed to consider, again, whether remarks on social media contributed to a hostile environment. So despite the proactive steps, which again, OCR made public and credited the institution for, there were these concerns that led to the resolution agreement. Next, the second to last one, I'm almost there, with the University of Illinois, again, a large public institution. Here, OCR was concerned about policies, right? Diffuse overlapping policies and procedures left the university community, at least in OCR's view, unclear about how to respond. So the takeaway here certainly is the importance of having these clear policies and kind of, we'll get to that in the best practice section, but to the extent that you have policies that are maybe that are less than robust or that you need to fill in, that's something that this decision can help with. And then finally, the agreement with Temple University. This one just occurred, just was published very recently. Again, here OCR credited the university for taking a number of proactive and responsive steps. But the main complaint here, the concern with OCR had, is the university's actions didn't consistently include steps to assess whether these incidents had noticed of an individual or created hostile environment for students, right? So we have reports addressed in isolation, in silos, and that was really the concern of OCR. And when you have these siloed reportings, especially at a large institution, it's kind of hard for an institution to determine whether a true hostile environment takes place or the extent or scope of it. So with that very high-level overview of OCR, recent decisions, today's second secret word is football. Please select the correct secret word. Please select football from the choices below.
I don't know why. I feel like we have a bias towards football secret words. It seems like in our presentations, they are very regularly, maybe that's just cultural these days, but I feel like we're leaving out other sports and activities. Yeah, I mean, you know, we could do classical music next time or something, seem a little more erudite. Hey, I also want to give a shout out while we're waiting just to Stephanie Fredman, who I know is working Stephanie through a little bit of a cold. And I very much appreciate you working through it, because it sounds good, by the way. Audio is good, but I know how hard that is. So thank you, ma'am, for doing so. Otherwise, I think we're probably getting pretty close. And Scott, appreciate so much, you know, going through all the different decisions. I know it's hard to find time when you're in-house and you've got work to do to pull those out and read through them. But there's not much of a substitute when you're really trying to get your mind around enforcement approach and attitude than actually working your way through some of that documentation. It can be just extremely informative. Or you can call Scott Goldschmidt on the phone. That's the other thing you can do. Just ask him for a summary. At any rate, I think we're probably pretty close. So, Scott, are you taking us into our next section, or are we handing it off again?
No, I'm not. I'm going to hand it over to Leah for her crystal ball predictions on
right.
Now that we've gone over the Biden administration's OCR. What are we going to expect on January 20th?
Yeah. Leah, you are being recorded, so we'll for posterity, we'll have to go back in a year and see how well you did.
Oh, yeah. I don't know about that, but we'll do our best here. So we kind of took you through the recent litigation and those OCR resolution agreements that have occurred previously. And if you're like all of us, that your question is, okay, well, what's going to happen next with this new administration that we have coming in? So like they said, we're going to kind of try to take out our crystal ball and do some predictions, and we'll see how accurate we are. The lucky thing here is that we have an incoming president who has had a prior administration, so we can look towards some things that happened in that prior administration to determine what we think might happen in this upcoming administration. So in 2019, we had an executive order issued by then President Trump on combating anti-Semitism. And what this executive order did was reaffirm a longstanding principle that anti-Semitism and discrimination against Jewish individuals based on their race, color, or national origin may violate Title VI. So this is what we were talking about. I think Scott mentioned it previously, that even though it's not a religious-based statute, Title VI, it does cover that shared ancestry. And so that's what this executive order was looking at. It also directed the federal government to enforce Title VI against prohibited forms of discrimination as vigorously as it does other forms of discrimination prohibited by Title VI. And it required the federal agencies to consider the International Holocaust Remembrance Alliance's working definition of anti-Semitism. And what that is, it states that anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews, rhetorical and physical manifestations of anti-Semitism directed towards Jewish or non-Jewish individuals and or their property, towards Jewish community institutions and religious facilities. So it encouraged and required those federal agencies to consider this definition of anti-Semitism when enforcing Title VI. And it kind of incorporated some contemporary examples of anti-Semitism in that enforcement. The first Trump administration was also outwardly hostile toward disparate impact discrimination. Remember, we talked earlier in this presentation about the difference between disparate treatment, which is that intentional discrimination, what we typically think about when we're talking about discrimination, and disparate impact, which is where we're focusing on the impacts of that discrimination. How did it affect people, even if it wasn't intentionally discriminatory, a policy or practice, for example? Like I said, the first Trump administration was hostile to the concept of disparate impact, and in its final days, it sought to enact regulations to really make a distinction and to say here, like on the paper, that disparate impact was not a type of claim that you could raise in the Title VI context. That did not go through, but it was one of the last things that the Trump administration tried to do in their first round through in office. So now we can look towards the future if we're talking about the incoming Trump administration. Particularly, we can look at Project 2025 and some quotes that are in that very long kind of plan for this incoming administration about Title VI. So they stated in Project 2025 that the Trump administration rescinded the Obama administration's guidance on school discipline. And what this was, it was regulations that sought to limit, or it was Obama-era guidance that encouraged schools to look at disparate impact in discipline. So it was saying disciplinary decisions often or were found to have a discriminatory disparate impact in the kind of Title VI context, and it was the Obama administration encouraging schools to look at that kind of discrimination. And so Project 2025 is saying, the Trump administration rescinded that guidance and corrected the overreach that they interpreted the Obama administration's guidance to be, and they encouraged the Trump administration in this next administration to continue that policy. And they were encouraging the Trump administration to take sweeping action to assure that disparate impact is no longer a part of the Title VI context. And so they were encouraging the DOJ and the Department of Ed to issue enforcement guidance stating that they will no longer investigate Title VI cases that are exclusively based on that disparate impact. And then they also really wanted the Secretary of Education and the Attorney General to work on a regulation to clarify outright that Title VI does not include disparate impact. We also see an increased focus on ending wokeness in higher education. That might be a term that you see frequently come up either in the news or on your campuses. And in Trump's campaign, we have seen promises to shutter those diversity programs in offices, your DEI offices, end of teaching critical race theory, gender ideologies. And they have proposed a number of ways that they would enforce these promises and these goals, which would be withholding federal dollars, like we discussed earlier, is an option that's been on the table, taxes or fines on endowments, opening those civil rights investigations, prioritizing those investigations in cases. And then also they have brought up kind of maybe implementing new expectations for accreditors and potentially using accreditation and their power over accreditors to have schools kind of fall in line with these goals that they have. We've also seen this kind of focus in a lot of state laws, particularly I'm in Texas. We see a lot of that, a lot of DEI focus in some of the state laws that have come through recently. So that is something that we expect to continue as we move into the next administration. We also have resolutions from Trump's first administration to look at. So like we went through all of those OCR resolutions that with Scott, we also have a few from Trump's first administration that can help us kind of read the tea leaves for this upcoming administration. So our first one that we're going to mention, and we're going to go through these kind of speedy like Scott did with the last ones just for time. But OCR entered into an agreement with Duke University in 2019. They had investigated whether there was a hostile environment created against students of Jewish descent on the basis of national origin. And in the agreement, OCR stated that Title VI prohibits discrimination on the basis of national origin, which includes that shared ancestry. So again, this is that area that we have looked at previously, that even though it's not a religious statute, it does prohibit discrimination on shared ancestry. And it includes and harassment that creates a hostile environment for individuals with that shared ancestry, such as students of Jewish descent, is a form of national origin discrimination, and a university's failure to address that harassment can violate Title VI. The last Trump-era OCR resolution we're going to look at was with Washington University in 2020, and OCR investigated whether the university violated Title VI by awarding student financial aid to students on the basis of race, either through the McLeod program, which is open only to African American students, or through other race-restricted financial aid programs. And the university agreed in this agreement to revise all race-restricted financial aid programs. And so students are now would be re-eligible to compete for those programs without regard to race, color, or national origin. And so it's important that we can see through these prior term resolutions that the Trump administration maintained a similar focus as to what we're seeing out of his campaign, and it likely provides a good indication of what may be to come. President-elect Trump also made a recent pick to run the Justice Department Civil Rights Division, and it only adds to this as his pick is known as a conservative civil rights activist who's been vocal about anti-Semitism on college campuses, so we do expect this to be a continued focus of the new administration. But of course, as the global political climate shifts, as we see every day, it's possible that we will see a shift in priority and focus of the Trump administration. And with that, I will turn it over to Stephanie to walk us through some best practices and tips.
Great, thanks, Leah. So this is the part of the presentation where I get to talk to you about some practical things, some ways that you can apply different tactics, tips, policies, things on your campus that are going to make you be in compliance with Title VI, or at least help that along. And kind of these come out of our experience. They also come out of some of the OCR resolutions that Scott was talking about earlier. So I'm excited to walk these through with you and kind of go over what some of these best practices and tips are for that Title VI compliance. So first, be mindful of potential changes in differing priorities from the incoming administration. So as Leah just mentioned, there may be changes that we see. There likely are going to be some changes between the Biden administration and the Trump administration in terms of just what the priorities are in terms of enforcement, investigation, all of that. So make sure that you are mindful of those things and that you're aware of those changing priorities and what may be just really kind of on the front of OCR's mind in terms of what enforcement is. Then consider how to implement takeaways from the current OCR resolution agreement. So Scott went over a number of these takeaways, and we're actually going to talk about a few of those takeaways in kind of practical terms here as well. But become familiar with some of those OCR resolution agreements and understand how other institutions have worked with OCR. So even from the previous Trump administration that Leah just went over, what are those takeaways and how to ensure that your school is in compliance with Title VI in terms of what those takeaways are. A really big one, and I'm going to focus on this a decent amount in the next couple minutes, is making sure that you are reviewing your non-discrimination policies and procedures and ensure that they cover all aspects of the institutional environment, including social media. Expect action even if a complainant doesn't respond, and require assessment to determine if a hostile work environment exists in all circumstances. So really, again, taking a look at those policies, understanding how they work, how a complainant actually makes the complaint, what the obligation is to respond to that, what the investigation looks like. Again, we're going to talk about this a little bit more too as we go through this. But earlier in the presentation, Leah was talking about investigations when it comes to hostile work environment. It's hostile work environments are something that, and I'm sorry, I'm saying hostile work environment. I really should just be saying hostile environment, not hostile work environment. You see how much of Title VII I do, and how that just rolls off my tongue. But hostile environment. So just ensuring that at your school, at your institution, that if you get a complaint, if that complaint comes in and is about a complaint of harassment, even if it's just one time, and even if you know that likely is not going to rise to the level of what a hostile environment is, legally under the law, look at that complaint and really think about, is this something we should be investigating? And likely there should be some investigation into what that is. And that's going to depend on a number of factors and on what the complaint is and, what that looks like. But if you get a complaint that a student is being targeted based on their race or based on a shared ancestry, that should certainly kind of just raise something in your brain of, maybe we should be looking into this, because, even though the student said it happened just one time, maybe we should open some kind of investigation. We often here at Thompson-Coburn, we look into these issues that arise on campuses in terms of hostile environments. And, they could be both in the workplace, but then also on the student side as well. And they often stem from just that one time, that one time a student was yelled at, and that was based or, had some type of racial stereotype that was involved. And especially if that student is then going through your complaint procedure in terms of what your policy looks like, really taking a look at that and seeing both what your policy says in terms of a response and investigation, but then also, even if it's outside of your policy, is this something that you should be responding to? And again, going back to the First Amendment, remember that protected speech does not relieve a school from its obligation to respond under Title VI. If the harassment creates a hostile work environment in a school. Again, this is a situation where maybe an investigation, maybe looking into something a little bit further may help you understand if this really nuanced piece of, is this protected speech? Is this creating discrimination? Is this creating a hostile work environment? And understanding who all the players are, what was said, what was done, all of that could be something that's very helpful.
Stephanie, you still keep saying hostile work environment. So just I know it's the flag, but it's a new hostile environment. I do want to make one point about the policies and procedures, because a number of schools we work with now, after Title IX and all the regulations, have these beautiful 40, 50, maybe not beautiful, long legalistic Title IX policies, and then their Title VI race discrimination, color, national origin is like a page. So not saying you need a 40, 50 page Title VI, but some parity, some time to, if you haven't dusted it off, time to do it. OCR has asked these in the resolution agreements, we had the big institutions to do the same. So certainly maybe worth a polish if you haven't looked at your Title VI policies in a little bit. Sorry, thanks, Stephanie.
No, thank you, Scott. And I apologize for continuing to just default back to hostile work environment. I do just mean hostile environment, and it gets both students and on college campuses. So,
hey, Stephanie, we'll fix it in post-production.
Yeah, right, exactly,
We'll edit that out.
Exactly.
Fair enough.
Okay, moving on to the next best practice tip we have here. So, per OCR, so looking at the OCR guidance and the resolutions, schools have a number of tools for responding to a hostile environment, and these tools include ones that don't restrict any rights that are protected by the First Amendment. So this is coming from OCR. So this is OCR saying that these are places where the First Amendment and Title VI are not at odds. So that would be communicating opposition to stereotypical and derogatory opinions, providing counseling and support for students affected by harassment, or taking steps to establish a welcoming and respectful school campus. And that can be, a range of things, and that can include what your values are, what your school values are, just ensuring that, that you're kind of staying true to who you are as an institution, and that, being a welcoming environment for all students. Other best practices are confirming there are robust processes in place for reporting and addressing reports of harassment or discrimination. So as Scott just mentioned, this is also particularly in light of the Title IX process. So, many of you, I'm sure, have heard us talk about the changes to Title IX and the recent changes to Title IX, and understanding that there is a very clear process on complaints and responding to complaints, and that you want to make sure that there's also a similar, it's not going to be identical, right? It's not going to be necessarily exactly the same of what's required under Title IX, but ensuring that there is a process for reporting things and responding to them. And that's really important for that Title VI compliance. And then evaluating your awareness of activities in the campus environment. So ensuring that the institution has a method for providing coordinated responses and tracking. And this is something that is coming across your whole campus, right? So it's not just going to be siloed in a department or siloed among, say, like a student group or student activities. This is going to be a way that you can ensure that there's a way to track all of this campus-wide across everybody. And then consider campus climate surveys or other mechanisms to gauge environment absent reports. Again, and I know I've touched on this already, but you want to evaluate your processes to ensure consistency. So it's that, that same concept of not really wanting this in a silo. You want to make sure that there's consistency across the board. You want to develop a standard for determining if there is a hostile environment, if one exists. You want to take certain actions in all complaints. So if you have that policy, make sure that you're following your policy. What happens? What are the steps that need to happen once a complaint is made? Acknowledge and offer supporting measures for individual complainants and groups. These can be things like increased security, convening meetings, and they might be other individualized resources. For those of you familiar with Title IX, you know that supportive measures analysis in the Title IX context is a really individualized thing, and that can be implemented in a sense here as well. Consider issuing a statement to the campus community, reaffirming the commitment to a campus free of harassment and discrimination, and assess the impact on the broader campus community and need for action beyond addressing the report. So what does this mean for the campus as a whole? What impact is the response going to be, and what impact is the complaint going to be? And does that help drive additional follow-up or additional things that happen as a result? Have a clear message and communication plan, and understand how a Title VI response may interplay with other institutional policies, values. This is things like codes of conduct. It might be things about demonstrations, other things that the First Amendment might be involved with, or if there's, as Scott mentioned, a number of the recent OCR resolutions have been in relation to this shared ancestry. So if there's other policies that you have about religious accommodations or those types of things, understanding how whatever response you have here may have an impact on that and may interplay with that. Training is huge. You need to make sure that your employees and staff, they're responsible for investigating. They're responsible for working through the policies. And if they are responsible for investigations, they need to be trained on that. But really, all staff, all employees should have an understanding of Title VI, and they should all be trained in some aspect on what this is and how to prevent it on campus. It's important that those that in that context too, that they understand what some of these differences are between the different compliance standards too of Title IX versus Title VI, or even Title VII too in the work environment as well. So we've seen that many places are requiring training for employees on anti-discrimination policies, and this would be a great time to kind of talk through what these things are and what the obligations are, even if it's a staff member who is not directly responsible for an investigation, or it's somebody who may not be, tasked with a direct response. There still should be some general understanding. And yeah, I mean, as I said, leverage your currently required trainings. You likely already require training on anti-discrimination policies, and use those and as a way to work in the requirements of what Title VI is and how to prevent discrimination of any kind on campus.
Very good. I think back to me, right? So we have a couple of scenarios here that have been put together. And I think what we'll do is we've also got a handful of questions. And so I want to have time to get to the questions. I think we can do one of the scenarios and then we'll move on to the question section. So I'm going to put on my best audible voice. This is my plan for retirement, to try to get hired as an audible narrator. All right. So a college student files a complaint with the dean of students. She alleges that the dry erase board on her dorm room door was defaced with swastikas. Additionally, she alleges the epithets referencing poor hygiene and racial impurity of Jewish people and white supremacist slogans stating conspiracy theories about Jewish people were scrawled on the door and posted by fellow students as comments to her social media feed. The student informs her school counselor of these incidents and that she no longer feels comfortable going to her dorm. The counselor has a meeting with the student to discuss her concerns, but failed to take any further action. So, Scott, I think I'll kick this to you first, and then maybe we can get thoughts from the others.
Happy to. Thanks, Aaron. Happy to take this one. I will mention before we start out, these are not Thompson-Coburn original scenarios. These are actually in the May Dear Colleague letter that we referenced. And so to the extent we don't get to some of them, those are available there and kind of gives OCR's interpretation of how to address them. But we thought we would at least try and highlight a few and maybe expand a little bit on how OCR or their justifications to handle it. But first thing to do, right, that last sentence, the counselor has a meeting, failed to take action. If this comes across your desk after that, first thing to do would be to take action, right? To do something to kind of to figure out what the next steps are, and that would be kind of consistent maybe with your newly reviewed and revised policies in terms of what actions to take, how to do it, who has to be involved, who's in charge of the investigation. But certainly OCR is, if they do kind of come knocking and in this fact pattern, they're going to look to see what have you done, right? And I'll go into what maybe next steps are, but just before I forget, whenever we have these conversations with individuals and we're going to take these really helpful actions consistent with the law, it's always helpful, it's always necessary to document it, right? OCR is going to look for that documentation, look for what actions have been taken. If it's not documented, it might not have occurred, right? So we're going to get this, it comes across our desk, we're going to review it and investigate it. Here, based on the facts we have, the harassment, right, appears to be based on Jewish ancestry or ethnic characteristics. We talked about the nuance and the facts of determination to kind of figure out if it is based on this shared ancestry protected by Title VI or religion, maybe where it would not be protected by Title VI. Here, the facts of the swastikas, the graffiti, the taunts, et cetera, make it at least plausible, right, that the alleged harassment appears to be based on this industry, it would be a Title VI matter, and certainly would be something that you should address as part of your policies. The next kind of step, right, is to determine if this is severe, pervasive, objectively offensive, meets the definition of a hostile environment, right? And so certainly we don't have enough. This is a 2-paragraph scenario. We don't have enough facts here, but certainly this could be severe, maybe if not pervasive. We want to do this investigation, learn how it affected individuals, whether others have been involved in it, and kind of go through your normal process when addressing these types of incidents. And if it does rise to the level of a hostile environment, right? If we determine that and we document it and we go through it, what are we going to do about it, right? Making sure we take prompt and effective action, calculated to end the harassment against the student, right? What are the supportive measures? What are the pieces that we would take against for this student to make sure that they feel safe and the harassment is ended for them? How do we eliminate a hostile environment and its effects for all other students, right? Do we have any video of what happened? Do we have any people coming forward? Do we have other incidents, et cetera? Do we have other dry erase things? How do we do things to eliminate the hostile environment? And then how do we prevent it from occurring, right? We talked about the Drexel OCR resolution, kind of things that they did that OCR credited them for, statements saying that we abhor this, we don't, this is anti-discriminatory values, we're going to have extra training, we're going to kind of have these public statements and trainings, et cetera. So kind of going through that analysis there is important when confronted with a situation like this. And Leah and Stephanie, I don't know, I tried to be comprehensive there, but I'd love any other thoughts and things that I missed or other things that you'd add to the analysis there.
I think you've got it covered, Scott. I think you were very comprehensive. Yeah, nothing really to add on my end.
Same. I mean, I think that this is an example of a time to continue to look into things and to not just say, oh, this happened one time. I mean, this is something that's significant and can be kind of one of those best practices of like, let's look into this further and see what's going on.
Very good. So let me suggest this. We have about 8 minutes. I want to get to some of the questions. I'm going to save the second scenario just in case Scott, Lee, and Stephanie blow through the questions at lightning speed. So hang in with us. I do want to hit on a couple of items before getting to the questions. So we'll come back to that second scenario. But first thing is, we do have one more secret word. So today's third secret word is Jersey. Please select the correct secret word from the choices shown below. So you can see Jersey is one of the options. Please make sure to select that if you're trying to get CLE today, because I want to make sure you get that CLE. And while you're doing that, I'll just talk through some of our resources. I have some slides here at the end, but while you're choosing your radio button here, we'll just get through it. So the first thing is, you're going to see there's a slide later in the deck. I'll just click through it here in 2 seconds. And it's our higher education resources page. And we got smart a few years ago, and all of our resources are now on that page. So blogs, compliance guides, white papers, training series, it's all on that one page. There's a QR code you can scan, or you can just go to Thompson Coburn Higher Education. It's all free. It includes links to all the webinars we do, like this one. So everything, we put it in one place to try to make it convenient for you all. And one thing I do want to highlight for those of you who may also be managing Title IX concerns, our 4-part Title IX training series that we did this summer, which takes into account the new Biden administration rule, is on that resources page and is free. And we understand some folks are in states that are currently subject to an injunction, others may not be, but just wanted to make sure you knew that resource in particular was out there. And again, that's got our blogs and our training resources and all those kinds of things. Okay. So hopefully you've had enough time to pick Jersey, and I'll just let the screen sit on the resources page. And while I do that, I'm going to start going to questions, and I'll do these in reverse chronological order. So we'll start with the earliest question that was asked. Are schools required to have a Title VI coordinator currently, or is that concept still pending?
So unlike Title IX, right? So Title IX regulations have a specific regulatory section stating you have to have a coordinator, what the coordinator has to do. There is no corresponding obligation under the Title VI regulation, so the 34 CFR Part 100. That said, might not be a bad idea, and it's something to consider. A lot of schools are moving in that direction, as Stephanie mentioned, either via litigation or otherwise. I mean, I think it is important to have individuals coordinate your responses to race, color, national origin harassment, whether you call it a Title VI coordinator or not. It's the same idea, but certainly that seems to be where the field is headed, to have those the individual and to kind of make sure that you're. I mean, the main takeaway, I think, is to just make sure you're resourcing and having a person that is tracking this, in charge of it, and kind of overseeing the university or the institution's responses.
Very good. All right, moving right along to our next question, and maybe I'll send this one, Stephanie, to you, our master of the hostile environment. What is best practice for assessing hostile environments?
So I don't think there's one best practice here. And I do think that it is going to be fact specific on what's going on. But I think ensuring, as Scott mentioned, that there is somebody in place in terms of a coordinator, some employee that's that person who can track what's going on, who is known to be the person that as a student you can go to and make a complaint. That then is really a great practice of providing a safe and welcoming space for students to come forward and say, I'm being subjected to this type of conduct. From there, the assessment really might turn into either what your policy has written, so following that policy, if that includes some kind of investigation, if that includes some kind of follow-up, that might be slightly different from that, but looking at what the facts are and doing more of sort of an individual assessment in terms of what this next step should be. And is it a full investigation, or is it speaking with the complainant, understanding more about just what happened and what occurred? So unfortunately there's no real totally set way to do it all, and every hostile environment is going to look slightly different based on what the facts are and what's being alleged. But just ensuring that you do have that team and that person that students can go to, I think is a really great best practice and next step.
Yeah, and I'll add too.
Go ahead, Scott. Sorry.
Thanks. No, just kind of as I think Stephanie alluded to in those the OCR resolutions and best practices, a lot of times you need someone to kind of have a 30,000-foot view of what's happening on the campus. And some schools got dinged with really great responses to individual situations, but kind of lost the forest for the trees and did not have a coordinated response or coordinated understanding of what is on campus. So part of the analysis needs to be looking at the individual situation, addressing that, but also in a broader context of the institutional environment, the campus climate.
And
yeah,
I'll
the challenge.
Just add one best practice. Of course, as an attorney, always documenting is very important, so we can show that we did this analysis. Kind of putting down those elements and writing down things that you have found that apply to those elements or do not support those elements. Things like that is just really important, particularly if an OCR complaint is filed regarding that incident, that you have the proof that we kind of undertook this analysis and this was the information that we had at the time.
Leah, I'm so glad you brought that up. That was the very first thing I was going to say at the beginning of the best practices, is that everything should be documented. So I'm so glad you brought that up. I forgot to mention that. So thank you.
Yeah. Well, I like Scott's comment regarding the forest and the trees. The problem in higher ed these days is there are just so many trees. So it's really hard to get back out and look at the forest sometimes. Okay. Yeah. So Leah, I'm gonna direct this one to you, and you just by luck of the draw I got the longest and most complex question I think we have. All right. So in the situation of protected speech on social media by a student or faculty member, I'm sure an investigation can happen and supportive measures be put in place for the impacted individuals' communities. But have you seen, or could you envision, sanction, discipline imposed if pervasive or severe enough? And would that be permissible under the law, academic freedom, open expression, etc.? Let me read it again, or you got it?
I think I got it. That is a very, like you alluded to, a very complex question. And so particularly if we're talking about social media, we have a number of issues here to consider when we're talking about social media versus on campus, employee versus student. It was also an issue that was raised here, but I think the main crux of the question is that First Amendment implication. And of course, if we're talking about a true First Amendment violation here, or we're talking about a true First Amendment protected speech here, I think that it is difficult to envision a time where punishment for that speech would be permissible. I am an attorney, so I never like to say never, but it is difficult for me to imagine a time where it would be permissible if it is truly protected speech. But that is one of those areas where we mentioned earlier that is such a just difficult, filled with a difficult minefield here of what is actually going to be protected, particularly in the university context, because another area of this question mentioned was the academic freedoms and things like that. There are just different considerations when it's campus speech and who is engaging in that. So would need a lot more facts on that one. But I'm curious about everyone else's thoughts.
No, I think you got that perfectly. And just the corollary to that, exactly what you said, that if it's not protected speech, then there's a little more discretion that you have here. So I think I think 100% agree with Leah. This is a pure First Amendment analysis, and even if you can take action, there's also a question of should you take action. So that was a good law review treatise. So I think yes, there are, if it is protected speech, probably not. If it is not protected speech, if it is outside the bounds of the First Amendment, it is possible, but consult with counsel. Maybe I'll say it that way as the recommendation there.
Yep, I think we have 2 questions left we'll try to hit, and this is timed out pretty nicely as it goes. Just one is a follow-up to the conversation you all were just having, and the question is if you can talk a little bit about those First Amendment protections and how those protections might differ in the context of public versus private nonprofit or private proprietary institutions.
Well, the First Amendment would apply to public schools. And so it's a lot, you have a lot more freedom if you're private in any stretch. And so in the private context, you're guided by your policies, and it's a contract kind of determination. A lot of schools, a lot of private schools will adopt faculty speech codes or academic freedom pieces. And so you could adopt elements of the First Amendment by choice. But just to be clear, and apologies if this wasn't clear at the outset, that we're talking in the First Amendment context about the implications to public institutions.
Very good. And the very last question that we'll hit today, do you have a sample policy available? And I'll answer this one. For a small fee, we can make anything available. All right, just kidding. But in all seriousness, if you have questions about Title VI or any other non-discrimination law, I encourage you to reach out to Scott or Leah or Stephanie, whether it be legal counsel or advice or policies, whether they be model or custom. Those are all the types of things that these 3, of course, do for a living, and would be delighted to help you out with. Again, we want to emphasize, we do think that Title VI is something that's going to be significant in a way that it has not previously been in the months and years to come. So for those of you who took the time to tune in today, we think you're wise to do so, and would be delighted to sort of work with you in thinking through that. The last thing I'll just say is, we don't know that we're going to have another webinar between now and the end of the year. So to all of you, happy holidays from the Thompson.
Sorry, Aaron, we are having one on the 18th.
We are. What is the one on the 18th?
Remind
me what it is.
TCPA updates. So super interesting.
Thank you so much. Gosh, I'm so glad you mentioned that. I mean, I'll still say happy Happy holidays, everybody. But that's right. We have a webinar next Wednesday on, boy, Stephanie Richter is going to kill me, our producer. So we have one next Wednesday on TCPA, Telephone Consumer Protection Act. That's going to be led by a number of our sort of litigation legal team within the higher ed group. And actually quite excellent. There have been changes in TCPA. So gosh, I'm so glad you reminded me of that, Scott. So at any rate, happy holidays until next Wednesday when we hope to see you again. And then we'll extend another round of happy holidays at that point. Otherwise, thanks to everybody. And please be well. And don't forget to fill out the post-webinar survey. Bye all.
Thanks all.